So happy Black Friday, everyone. Today, uh, realized it's been a while since I made a video, so I thought I would throw up the slide deck from Chile and my talk about free speech and just cover it again. So, again, this is the way it was explained to me recently in a continuing education course. So, free speech is basically comes down into unconditionally qualified speech, which means the government can't regulate it, and unconditionally disqualified speech, which is basically never considered free speech. So free speech on the First Amendment, unconditionally qualified, is if you're speaking about matters of public interest or concern, can still be regulated, but only based on time, place, and manner, not on the content of the speech. So basically, if you were preaching in front of a courthouse and saying homophobic things, they couldn't specifically pass a regulation saying you can't make homophobic political speech. But it has to be political, right? You have to say these people don't deserve rights. You can't just, be obscene. And you could do that. The government could pass laws saying you can only do that at certain times and places and manners. As long as in general you could do it in as many places as you couldn't do it. Right. So then, basically, unconditionally disqualified speech is fighting words. So fighting words comes from a really old case law that basically says if you utter these words that are so offensive that they would cause someone to immediately become violent, that those are called fighting words, and free speech was never meant to cover that. So a lot of the laws that cover fighting words are breach of peace laws and disorderly conduct laws. One interesting thing about the fighting words doctrine is, there's a lot of interesting things. So first of all, right, because it's very incident specific or circumstance specific. So I talked about before, like people say Chile's a hothead, right? So almost anything that you say to him might not be protected free speech because there might be fighting words, right? So you're really better off saying he's not hot-headed if you want to call him names. But in general, right, it depends a lot on the age and of the speakers and the gender. There's so many things. Like if a 90-year-old lady cusses you out, are you likely to be violent towards her? Especially if she holds a cane. And then also, if you cuss out a 90-year-old woman with a cane, do you expect her to become violent? So another thing is a lot of the case law says that basically that police officers should be held to a higher standard, that police officers should be able to be cussed at without immediately going to becoming violent. That so when you take that into account, you're automatically supposed to consider that based on case law, that the police officer is less likely to become violent. Like that might be a jury instruction even. Now you need to take into the fact that they're a police officer. It's funny, in the auditing community, right? We find out that police officers are less likely to be able to withstand fighting words and stay non-reactive. We often see them get pissed, right? Their faces turn red, and and escalate things instead of the other way around. So, additionally, unconditionally disqualified words are legally obscene material. So, I mentioned with Chile, right? That's the whole Larry Flint hustler thing. I think the, the test that they actually use is like Williams or Miller test. I don't know, one of those. I probably should refresh my memory, but so it's not the Larry Flint test. There is a name for it, but most people think of Larry Flint. So defamation and perjury. So defamation again is words that injure someone's reputation, and a lot of people think if they're true, it's okay, but I mean, the way that it's supposed to be handled is that truth is the defense. It's not, doesn't give you the right to say it. And then perjury, of course, is frowned upon. And then true threats, where you say something and someone has legitimate fear of violence or whatever. All right. So everything else, all other speech, like I don't know, the speech that you have in your living room with your family members is not guaranteed. And most of the protections for that type of speech that's not of public interest or concern is based more on the 14th Amendment. So it's not guaranteed. It can be regulated. The only reason you can call someone bad words is because, right, that's not of public interest or concern, is because it's not regulated. It's not because it's free speech. And then it soon becomes regulated because most states do have harassment laws that if you continue to do it, then you're starting to infringe upon the other person's rights. But in general, just saying something once that would be offensive is typically, going to be all right. It's not free speech under the First Amendment, but most people are expected to have, kind of a thicker shell and be able to handle some bad speech as long as they're not fighting words. So, I mean, and then they're expected to be violent, but I don't know if that's ever been determined that when someone was violent after using fighting words that they were, like got away with being violent. So it's kind of a weird doctrine. It's archaic. So, all right. So basically, the other speech shouldn't violate someone else's rights, and they're protected by it's your liberty protected by due process under the 14th Amendment. That was weird. So I had a problem switching slides. I had to click the button twice for some reason. So here's the legal descriptions for free speech. I mean, you can refer to the First Amendment for the way it's written, but this is how it's interpreted. So most typically, freedom of speech is thought to optimally promote the pursuit of truth, the goal of autonomy, self-realization, or personal flourishing in a genuinely meaningful, representative democratic process. So this is basically what I talked about, right? That free speech is speech about public concern. So in a famous decision in 1919 by Oliver Wendell Holmes Jr., interestingly enough, his opinion was the second statement, and at that time it was the dissenting opinion. So that he said, the purpose of this free speech clause is to protect the market and ideas, broadly understood as the public expression of ideas, narratives, concepts, imagery, opinions, scientific, political, or aesthetic to an audience whom the speaker seeks to inform, edify, or entertain. So this is what a lot of people think of as free speech, right? Like, especially your artistic creativity freedom to speak, right? If you're a performance artist, maybe this is what you think about. And it's interesting too because it's about who you seek to inform, edify, or entertain. It doesn't matter what the recipient of the speech cares. So um, this dissenting opinion is what was quoted when Jehovah's Witnesses won their case about passing out flyers. So someone tried to pass the local ordinance saying that they couldn't, pass out flyers, but they were trying to inform people who weren't necessarily open to it, and it was considered free speech, and the statute was not enforceable. All right, so casual chit chat between two persons or otherwise confined to a small social group is unrelated or largely so to that marketplace and is not protected. So such conversation is important to its participants, but not to the advancement of knowledge, the transformation of taste, political change, cultural expression, and the other objectives, values, and consequences of the speech that is protected by the First Amendment. So I would say that most of the speech on YouTube panels that you see is not protected, right? Because it's between a small group of people. Just because they broadcast that speech between that small group of people to the internet at the same time or at a later time doesn't necessarily make it free speech. The other thing is this was the dissenting opinion in 1919, but starting in the mid to late 1970s, it started to be cited a lot more often in winning court cases. So slowly, we're making our way to more free speech that doesn't have to be about public concern, but it's moving slowly. But eventually, one day, I think, drug companies would say a drug cures cancer when it doesn't, when it kills you, because eventually, that's their right to free speech, right? Doesn't matter who it harms. All right, so my last slide is this interesting one. So it says, this was a case that was discussing fighting words, and it actually was between like a senior citizen lady with a cane. And she said these words: fat, ugly, B word, C word, and F word. You're not a manager. So the judge. So fighting words, right? If you just use words that have no other meaning, it's definitely going to be considered fighting words. But if you use words that have a meaning, the court is going to do its best to interpret what you meant. And this court found the person judicially found to express frustration at not being able to obtain services to which the defendant thought she was entitled. So for fighting words, right? There's a lot of words that have alternate meanings that are curse words that are typically considered obscene that have other meanings. I'm not going to say them because I don't want to have a adults only strike on this video, but it's interesting because now for fighting words, what courts will do now is they'll actually figure out, right, was there an actual meaning, or were they just intended to hurt the other person's feelings, right? So it was determined that these words actually did have a meaning. So then to determine whether they should be considered fighting words, then the jury was instructed to try and determine the difference between the kinder way and the meaner way that was said to determine if it was protected speech or not. So that's all I got. I see a lot of people are talking about wiretapping and two-party and one-party stuff, and I recently consulted with some people on how that is actually typically determined in case law. So it's probably gonna be my next video. We'll see. Have a good one, everyone. Bye.